This module is about reading contracts. Now, I know what you're thinking. You're thinking that you're going to have lawyers to help you if you have to write a good contract, or if you have to read, evaluate, and sign a good contract. And that's certainly true. You should always have lawyers work with you when the stakes are high or the contract is complicated. That said, for what we're doing, you still want to be able to be comfortable reading a contract. Most importantly, you're going to know the business deal better. You're going to understand the purpose behind the contract. You're going to understand what's going on behind the scenes that led to this moment. You can't give all of that to the lawyer. You can try your best, but you want to be able to read the documents too, talk to counsel, and make sure everything's been implemented the way it should. For that reason, I want to get you comfortable reading contracts, and in particular, comfortable reading contracts related to intellectual property. Before we turn to some specific examples, I want to make 4 high-level points about contracts and how we should think about them. My first point is that contracts are in part about enforcement. What do I mean by that? Well, one reason we have contracts is the obvious one. We put down on a piece of paper what it is you're going to do and what it is I'm going to do, so that if either one of us doesn't come through, we can later go to court or go to arbitration and figure out what happens now. So sure, we might have a contract where you promise to paint my house and I promise to pay under certain patterns and conditions. And then as we both go to do what we're supposed to do, there's a fight, there's a disagreement. And in that case, it's the standard use of a contract. The document will help other people figure out who did what wrong and what should happen now. Do I have to pay you anyway? Do you have to redo the work? And so on. So sure, contracts are in part about enforcement. But contracts also help ensure the meeting of the minds. That is, the contract isn't only about enforcing a deal if it goes badly. It's also about making sure that you and I both understand what we're getting into. Think about it, very few contracts actually go to litigation. Very few contracts go to arbitration either. For the most part, the real reason we write a contract is it forces us to look at the details together. I put my pen onto a piece of paper and I indicate clearly when I'm going to pay you and what I'm going to pay you for. And as I struggle to write that, or as you read what I wrote, we both begin to get clarity about the job and what we're each committing to do and to not do. Writing the contract, negotiating the contract, signing the contract, reading the final version, it's really helpful for you and for me just to reduce the odds that we're getting into a deal we don't want to be in. It might become clear as we read the contract that this isn't a good deal for you, or that we hadn't thought of some important conditions, like who's paying for the paint. And so by having to write down the contract and create this document that could be used later for enforcement, we're doing the even more important task of ensuring a meeting of the minds. We're going to see details, we're going to see puzzles, we're going to see things that we might not have thought to talk about, that now when we go to put pen to paper, we'll realize we have to agree on before we get started. For this purpose, contracts should be written in clear language, right? If we're trying to write a contract to make sure you really understand what I mean when I say paint my house, and I really understand when the money's due and why and so on, we want to write it in a way that both of us will understand. Not just that our lawyers can do it or the courts can do it, but you and me. The purpose of a contract along this dimension is to educate both sides as to the deal we're trying to consummate. The meeting of the minds. The third big idea I want to introduce as we get started is this idea that contract language is often unclear because of precedent. What I mean here is that a lot of the language lawyers use in contracts comes from old cases. Think about what that means for a second. There was somebody else who wrote a contract a long time ago, and the language was so unclear that there had to be a court case to fight about what the words meant. There was, a court looked at the words, figured out what they meant, and ruled. Those words mean as follows. Well, now, a lawyer writing today will often be tempted to use those horrible, confusing words. Why? Because a court's already read them, and a court has already said exactly what they mean. And so because of precedent, because we have old contract disputes that courts have resolved, and those cases interpret language, we often see really bad language echoed again and again in later contracts by design. I want to use that bad language because some court has already told me what it means. This is my favorite example along those lines. A long time ago, a lawyer had a situation where he had to write a contract that would mean that being late is a horrible, horrible violation of the contract. You can't be a minute late, you can't be a second late, you can't be an hour late. I don't want you to be late at all. That's what he wanted to say. But instead of saying it that way, in a way that's completely understandable, the lawyer chose this flowery phrase. The lawyer wrote, "Time is of the essence." Now, between you and me, that's a horrible way to say, don't be late at all. Much better to say, don't be late at all, not even a second. If you're late at all, it's a huge breach of this contract with the following consequences. But no, the lawyer wrote, "Time is of the essence." It turns out in that situation, someone was late, and there was then a dispute about is being late okay, and how bad is it really? Come on. And so the parties went to court, and the court had to listen to arguments with one side saying, "Time is of the essence" means don't be late at all. And the other side saying, "Time is of the essence" means you could be a little late, time's important, but come on. The court heard all that. The court ultimately ruled that time is of the essence means you can't be late at all. So fast forward to modern times. Lawyers who want to get that idea into their contract are tempted to use this phrase. Why? Well, not because it's clear, not because it does a good job of helping both sides understand the deal, but instead because there are famous court cases that tell us what it means. And so lawyers like to use phrases that have been interpreted by court cases because that gives them the extra confidence that their phrase will be read the way they want it read. So you see things like this, like time is of the essence being used in a contract because it has embedded meaning, because a court has already ruled on it. And again, it's a little bit ironic because the court doesn't have to rule on clear, good, well-written language. And so the language that gets locked in, ironically, is this bad language, language that was so unclear that we had to have a court look at it. I'll say to all of you, I try my best to avoid these things and instead write good, clear, original language, because my view is that one of the most important things the contract is supposed to do is to educate both parties. And so writing time is of the essence, wink, wink, nudge, nudge, we lawyers know what that means, that doesn't really help the parties. Whereas instead, if I write, this is a contract that you cannot be late for at all, not even a minute, that helps the parties understand, and I'm pretty sure a court would get it right too. Back to my 4 big points. We've covered the first 3. We've covered the first point, that contracts are in part about enforcement, the second point about contracts helping with the meeting of the minds, and the third point that contract language is often unclear because of precedent. But let's look at the fourth. I note that contract language is often written to be belt and suspenders. What do I mean by that one? Well, think of a copyright example. Imagine you and I are working together on a project, and what I want at the end of the project is I want that I have full control over our joint output. Now, one way I could do that would be to characterize you as an employee, because if you were my employee, the law is such that as my employee, all of your rights would go to me as employer. If that doesn't work, though, there are other ways to get basically the same outcome. For instance, I could recognize you as a completely separate, independent contractor, but then, through a written document, have you transfer all of your rights to me, just with some simple sentences that say whatever rights you have, go to me. There are other ways, too. My point is, in a good contract, I might do all of that. I might write one clause that says you're an employee. I might write a follow-on clause that says, to the extent you're not an employee for any reason, you move your rights to me anyway. And a third clause and a fourth clause, right? Belt and suspenders. The thing I want to achieve at the end of the document is that all of your rights go to me, so I'm in control of our joint effort. And because there are a bunch of ways to do it and they have imperfections and I might mess them up, I could well want to write a document that does all of them. Here's one way I get that outcome. Here's an alternative way to get that outcome. Here's a third choice way to get that outcome. Belt and suspenders. This way I can have confidence that the contract's going to get me where I need to go, even if there's some technicality I missed. Okay, those are my 4 big introductory points. Let's take a look at some contracts and some specific examples that go with them. The first example I want to look at is a pair of contracts between these 2 companies, a company called Universal Display and a company you know, Samsung. Universal Display has worked for many years trying to develop certain kinds of technologies that can be used to make vibrant, low-power screens. The technology we're going to focus on in our conversation is something called phosphorescent OLED. And the details aren't terribly important. What's important to know is it's a developing technology. In the 2005-ish timeframe, Samsung was just beginning to go ahead and use this technology in its smartphones. So the screen on your smartphone would have phosphorescent OLED as the technology as compared to something else like LCD or regular OLED and other things. They were using this technology, and even now in 2015, this is still a technology that folks are trying to sharpen and make better, say, for using it on televisions, right, giant screens. But what's interesting about phosphorescent OLED is, if it works and if we can get it fully up and running, it has some charms. It gives you a really nice picture, and it uses incredibly little amounts of energy. So great for battery life, great in terms of just the cost of operating these devices. It also has a few other charms. One of my favorites is that the technology can be used on a flexible plastic screen. So you could bend the screen, for instance, instead of having it be rigid. You can also make it so your smartphone can be dropped and the screen won't shatter because the screen can be bendable, hence it can take that hit, unlike a glass or a rigid plastic, which wouldn't. So Universal Display has been working on this technology for many, many years, has a bunch of patents. Samsung, at the time the contracts we'll look at, again around 2005, they're beginning to roll out smartphones with these screens. They're also dreaming of televisions even back then. And so these are the contracts about licensing Universal Display's patents to our friends at Samsung. This is just a quick image of the bendable screen, just in case my words don't capture it as well as an image might. Literally, check that out. You can bend the screen. You could think of, say, reimagining the Fitbit, right? Goes around your wrist. I can put a screen on there with this technology. Perfectly bendable, can take impact, and give you cool information. So too, as I say, inside phones, all sorts of really interesting uses for this technology. As we head over to the contracts, I want to flag the issue. So what's the big thing these guys are struggling with as they go to write a contract licensing Samsung to use Universal Display's patents? And here, as I understand it, is what the big issue was. I should say, by the way, I was not involved in this. I'm getting all this information from public documents, and indeed you'll see my copies of the documents are pretty unattractive. I always make sure to grab only completely public things to use in teaching, and so the contracts here come from a public source, and they're just not pretty. But what I think the issue was when Samsung and Universal Display was originally cutting this deal, I think the issue is the one on the screen. The question was whether Universal Display's patents on phosphorescent materials would be valid, and as a practical matter, whether they'd be enforceable during the term of the contract. Let me say that another way. Universal Display had a huge number of patents. They'd been working in this area for a while, spending real money, and they had patents about all sorts of things relevant to phosphorescent OLED. They had patents about things you can add to the material, for instance, to make it more stable or brighter. They'd been working on fancy colors that other people weren't able to produce. They were working on manufacturing technologies of how do you get the phosphorescent material into the electronic device. On and on. They had a bunch of cool patents, a bunch of cool ideas about what do you do with phosphorescent OLED. And there wasn't a huge controversy about those things. This company was early in the development of these technologies. They also had bought out some other companies that were early. They had a good patent portfolio on that mix of ideas. The controversial bit was they also had patents that purported to cover phosphorescent material itself. So they had patents on the material you needed to use to make phosphorescent OLED. Not the OLED, not the electronic component, not the screen. They had those too, but the controversial patents were the patents on the underlying material. Did Universal Display, in addition to having all these patents about the screen and the technology and manufacturing and uses and bendable and all these things, did they also have patents that let them corner the market on the material itself? And that, I think, was the big fight at the time these contracts had to be signed. I think Universal Display believed that its patents were valid and could be enforced. They were good enough. They had enough of an international footprint that they could control this market in Asia and in India and in the US. By contrast, I think Samsung was skeptical. And the reason I believe Samsung was skeptical is in part because of the contracts I'm about to show you, and in part because I know at this time there are proceedings underway all over the world. In Japan, in Korea, in Europe, in the United States. There are proceedings all over the world where people were challenging these patents. Not all the patents. There weren't fights over Universal Display's other stuff. But the patents on the phosphorescent material were being challenged. People were coming forward in various procedures and saying, you know what? We think these materials have been around for a long time, even if no one has used them to make screens before. So I think there was a real fight and maybe a real disagreement between Samsung and Universal Display over whether those patents were good enough. And so as they wrote down contract documents, I think each side wanted to bet on its own view of that issue. So they both wanted to throw down together on a license to most of the patents, but then they needed to somehow treat specially the patents about the materials. Universal Display wanted to bet the contract on that. If those material patents hold up and they are enforceable as a practical matter, they wanted to get paid. And Samsung, I think, on the other side, wanted some flexibility. If the patents didn't hold up, if they weren't enforceable, Samsung wanted to at least be able to buy materials cheap from somebody else. So I think that's the issue. Let's look at the contracts and some basics of a contract, and then we'll also see how that issue played out. So here is one of two contracts the parties signed on April 19th, 2005. And again, I apologize for the quality of the image on the screen. Note that you have access to the PDF version, which is a little bit more legible, and I'll read you the key parts also. But this is the actual document. I have it because it was released in an SEC filing. So this is material to the company, and they disclosed it to the SEC, which means it's a public document. It's edited. They cross off a bunch of the price terms for obvious reasons, but that's how we have this at all. But for our purposes, it's actually great. So this is the original contract, and I'll tell you, we'll see it in a second, but I'll tell you, this is the contract that covers all the not-so-controversial patents. So not the materials ones, but everything else. And let's take a look. It opens up with this language. It says, this OLED patent license agreement is entered into effective as of April 19th, 2005, the effective date, by and between Samsung, and they identify Samsung specifically, and Universal Display Corporation. Next up are these whereas clauses. In this contract, they're really thin and really short and mildly uninteresting, but in other contracts, you'll see this as kind of the setup, just so a later reader understands, hey, here's what's going on. Here's why this contract was written, because sometimes context will help you interpret the contract. Here, again, pretty straightforward. The whereas clauses read, whereas Universal Display has rights in certain patents concerning organic light-emitting devices, that's OLED, that's this technology for the screen, and whereas Samsung desires to obtain license rights to practice under these patents on the terms and conditions of the document. Now, therefore, intending to be legally bound, Samsung and Universal Display agree as follows. Again, not much interesting there. Next up, we get some definitions. Always, always, always look at the definitions, because there will be words in a contract that you think you know what they mean, and they don't. And so you want to make sure you see what the definitions are. So many deals rise and fall on this kind of detail. Here are the definitions they made in this particular contract. 1.2. A licensed product. A licensed product means an OLED display module made using a permitted process, or any product or part thereof that incorporates such an OLED display module, which OLED module A is covered in whole or in part by an invalid claim of a relevant patent, or B, is manufactured using a process that is covered in whole or in part by a valid claim of a patent. So note, as we talk about the licensed products, we're defining a particular set of products here in light of the patents that are going to be triggered, right? It's a product that's covered in whole or in part by a valid claim, or a manufacturing process that is claimed is used to make the product. So we're trying to talk about what the licensed product are, and we get this kind of awkward definition as to what they are. Again, we'll see more in a moment. This is a little bit more from the same part of the contract, more definitions. We get a definition of an OLED. So an OLED, or an organic light-emitting device, means a device consisting of two electrodes, at least one of which is transparent, together with one or more chemical substances deposited between these two electrodes, at least one of which is an organic or organometallic material, which device emits light when a voltage applied. What's interesting about that? Where they're defining the OLED and pointing out that there's something between the electrodes, right? That's the material that's controversial, right? The chemical substance between the electrode, it's those patents that are a little bit messy. Everything else, the bigger stuff, less controversial. So we're just getting layers of definitions that you'll see will then be used to really sharpen what the parties agree and disagree on. Gonna skip a few of the others, go down to 1.8. Phosphorescent material. This is the stuff everyone's fighting over. Phosphorescent material means an organometallic or other organic material that, when used in the emissive layer of an OLED, emits radiation from a triplet excited state or enhances the emission of radiation through phosphorescent sensitization. Again, the detail's not critical to us. What I want to point out to you is they're separately defining the material so they can cut it out of this deal. Last definition down there, universal display patents. Universal display patents means all patents, the design patents and the utility models, A, issued, registered in the world as the effective date, or B, issued or registered during the term of this agreement from the patent applications filed before or during the agreement, which universal display owns, or has the right to license from third parties, such as some of the partners like Princeton and Motorola and the like. So we get a definition of which patents we're dealing with. Note at the end, it says including, but not limited to, and they gave an exhibit listing them. Okay, last part of the definitions. 1.11 defines what it means to be a valid claim. A valid claim means a claim of an issued and unexpired patent, which claim has not been finally held unpatentable, invalid, or unenforceable. So a valid claim is a claim of a patent that's still out there, right, that hasn't been completely eliminated by some legal process. Okay, what did all that do? That just gave us vocabulary, gave us words we can use to now really clearly say what rights everyone's getting and what obligations everyone's picking up. And that's Article 2, the license rights. Here we go in 2.1. Subject to the rest of this provision, Universal Display hereby grants to Samsung a worldwide, royalty-bearing, non-exclusive, and non-transferable license under the Universal Display patents solely to manufacture, have manufactured, sell, offer to sell, use, and import the licensed products. So Samsung gets a worldwide license. Makes sense. Samsung is doing things all over the world. It's royalty-bearing. They have to be paying royalties. We'll find out the details later. But the more they sell, the more they're going to pay, at least once they clear a minimum. It's non-exclusive. So somebody else could get a license also, maybe LG, who will turn out to also get a license later to make devices and also televisions. And it's non-transferable with some limitations, but non-transferable, like Samsung don't buy it and then start being a kingmaker and let everyone else use these patents too. So Universal Display gives a worldwide, royalty-bearing, non-exclusive, non-transferable license to manufacture, to have manufactured, to sell, to offer to sell, to use, and import. Lots of rights, basically, to the portfolio. 2.2. There's also license rights to future patents. This is going to say what you expect it to say, that there's going to be more patents coming down the pike, and they're going to get grandfathered into this deal. Here's the fun provision, though, that begins to point out, something's going on. 2.3, there's no right to make OLED materials. Right? You can make phones, sure. You can make screens, but you can't make the material you need to actually make them work. except as may otherwise be expressly agreed to by the parties in writing. Nothing in this agreement shall be construed as authorizing or otherwise permitting Samsung or its licensees or any third parties claiming through them to practice under any universal display patents for purposes of manufacturing phosphorescent materials. So even under this deal, while Samsung's allowed to use all the other patents, they get no rights to make materials. Now, let's just pause for a second. If the patents are no good, that is to say, if the patents and the materials aren't going to stand up, I don't need rights. Right? If I'm Samsung, you didn't give me rights, well, who cares? You didn't have rights to begin with. But if the patents are good, if the patents do hold up, if people are respecting the patents all over the world, then the fact that I don't have rights means I can't self-provide or buy or create this material. I got to call up Universal Display and get it. So by carving them out, this doesn't say Samsung's not allowed to have its hands on phosphorescent material. It just says, look, we didn't authorize that in this deal. So if we turn out to have valid rights about material, you're in trouble, right? You're going to have to come buy it from us because you don't have those rights. You got everything else you might need, but not those. We'll come back to that issue in a second. Let's look at a few more things just as we go down the document. This is an important clause talking about improvements. In a lot of contracts, I'm going to license you to use my patents, but then I know and you know that as you use them, you're going to have good ideas related to mine that make my stuff better. We always want to put a clause in that says what happens to those good ideas. It might be our clause will say that you get them. It might be our clause will say I get them. It might be our clause will say we share them. There's a whole bunch of ways to kind of split the baby. Point is, this is an important thing to think about. If you are taking my pioneering screen technology and you're going to be among the first, if not the first, to really use it commercially, to mass produce smartphones, to mass produce televisions, who knows what else, I should expect that you're going to come up with some cool stuff. Some cool ways to manufacture using it, for instance. Maybe some additives that make it better, brighter, more useful in certain situations. Who knows? And knowing that we need to have some sort of deal about, all right, what happens when you come up with a good idea? Do you have to tell me? Do we share the rights? And on and on. And they've got a clause like that in this contract. That's the one highlighted on your screen. Another clause I just want to point out is this patent validity clause. What Universal Display wants is they want Samsung to not challenge the patents. Right? Come license and then don't bug me. Don't license and then argue in court my patents are no good. Don't license and help somebody else take shots at me. I want you to become part of my team, license, and then pay. And so they put a clause about that. To the extent permitted by law, there's cases that make it clear that this might not be okay. We might want to always allow licensees to challenge the patents they license. Whereas a policy ground, Samsung's a pretty good choice to fight these patents. They'll know a ton about them. They know a ton about the technology. Maybe we want to trump this provision as a matter of law and say, look, you can always question a patent. So they have to say to the extent permitted by law. They don't know how it's going to play out. Yet at the time they wrote this, the rules were slightly different than they are today, and who knows what tomorrow will bring. But to the extent permitted by law, Samsung shall not, and shall ensure that its permitted sublicensees do not, challenge or assist others in challenging the validity or enforceability of any of the Universal Display patents. On and on and on. Right? A clause saying, don't fight us on our core asset. Okay, just a little bit more. Here's the payment stuff. Article 4, consideration. What are you going to pay for all these rights and the limitations? There's a license fee, right? There's a license fee. There's basically going to be a fee up front. We don't get the details. It's in Exhibit B, which we don't get access to. But there's something they have to pay, kind of a bare minimum. And then in 4.2, there are running royalties. Royalties based on net sales revenue of these Samsung devices. So it looks like it's kind of a lump sum followed by a variable portion that varies with Samsung's success. Okay, all that was the first contract, the contract that talked about the patents that were less controversial and cut out materials. Now here is the contract about materials, and it starts to some degree the same way. Up at the top, we name it. This is the OLED Supplemental License Agreement, right? It's a supplement to the other one. It's entered into effective April 19th, 2005, same day as the other one, between the same parties, unsurprisingly. We have the whereas clauses, this time setting up this supplemental contract, whereas Universal Display makes and sells certain materials for use in OLEDs, whereas Samsung wants to purchase these materials from Universal Display, whereas the companies have on this date entered into the main agreement that we just looked at, whereas terms not defined herein shall have the meanings ascribed to them in the main agreement, now, therefore, intending to be legally bound. Here we go. Right, this one sets up that Samsung wants to buy materials from Universal Display. And, footnote, wants to? It's a little bit of a fight, right? This is the contract about buying materials, but again, because we've separated it from the other deal, we're letting Samsung make a different bet about materials as compared to the bet it makes about everything else. What do we get? Well, down here at the bottom is, I think, the interesting clause, the reservation of rights. Nothing herein shall be construed as a license by Universal Display for Samsung or any of its partners or any permitted sub-licensee or third-party manufacturer to manufacture or sell to Samsung. Got to skip all that next language. But to manufacture or sell to Samsung any phosphorescent material. Let me highlight that so you can see where I am. Any phosphorescent material or other OLED material covered by the Universal Display patents or Universal Display otherwise as a proprietary interest. Right? Sorry for the language here. All this extra words makes it hard to read. Right? But it's saying, look, you didn't get a license for the phosphorescent material. Right? You don't have a license for that. You can buy it. This is the country you're buying it, but you don't have patent rights. So if you buy it from us, fine. But if you buy it from someone else, or if you make it yourself, you don't have patent rights to do that. You might get in trouble with us, right? Universal Display acknowledges that Universal Display, is responsible in its discretion for enforcing its patents and its other proprietary rights against other suppliers endeavoring to make or sell such material without appropriate licenses, right? So I get it. Universal Display, if you think you have patents and materials, your job to enforce them, not Samsung. Samsung's not going to become your policeman. But as you keep going, nevertheless, Samsung shall refrain from and shall cause its sub-licensees to refrain from encouraging other suppliers to make or develop phosphorescent material with the knowledge that the manufacture or development of such material shall use or need to use any Universal Display intellectual property right. What does all that mean? Well, we didn't get rights as Samsung to these patents. That's pretty clear, carved out of both contracts. We have this agreement, we'll look at another clause in a second, but an agreement which says we can buy it from you. Here are the terms. We can buy it from Universal Display. Then we have this recognition that other people might also be selling it, right? If the patents turn out to be weak, other people will step into the market and start selling phosphorescent material. And then the question is, can Samsung buy from them, right? Do they have to wait till the patents blow up? And at that moment, there would be no intellectual property right to worry about? Can they buy during the term of the contract even if the patents have not blown up? Say some manufacturer in Asia starts making phosphorescent material, Samsung wants to buy it. They're not going to encourage them, not going to say, hey, go do that for me, but it's available in the competitive market since they go buy it. Right? There's a little bit of an interpretive question of what does this allow, but there's some wiggle room built in here. Right? And again, maybe the ambiguity was left because the parties really couldn't come to an agreement. But there's some wiggle room here for Samsung to go buy materials elsewhere. They have this contract where they can buy from Universal Display under terms that were negotiated on this date, but they can opt not to. If that patent estate proves weak enough, if the patents are invalid, if they can't be enforced in Asia, all of a sudden Samsung might be able to wiggle out. They still pay under the first contract for all the other patents, but materials, they can go buy them at a competitive rate instead of it under the rate under this contract. Okay, let me clear all those markings away now. I told you a second ago I'd show you the prices. I actually lied. I can't show you the prices. It's all been crossed off in this document. All we have is that. Samsung's going to pay for the purchase, but this is a confidential material that's not out there. I can tell you what we know. Since this happened so long ago, we've got to see financial reporting from Universal Display over time. We also got commentary from the executives. And what we know is there was a minimum purchase requirement in the deal. So when Samsung cut this deal, whatever flexibility they got, they did agree to a minimum purchase, which they obviously made over the terms of the deal. So they had a minimum amount they had to buy from Universal Display, and then they had some flexibility Beyond that, to buy from other folks, maybe setting up litigation. Maybe Universal Display would go after Samsung or those other folks for using the material without permission, for making the material without permission, for selling the material without permission. But there's a minimum under the deal, but no obligation to buy everything. And indeed, what's been interesting, it's now many years after 2005, and what we saw is Universal Display gradually has started to see that it makes more of its money under its deals for the not-so-controversial patents than it does in its materials business. So if you scroll back to, say, 2006, 2007, we think that Samsung was paying under both of these deals a pretty penny, right? Hitting the minimums, maybe a little more, but paying under both halves. Over time, what we think we see is that Universal Display started to skew, and they were really making the money on the patents under the first deal, but they weren't selling as much material. And part of the explanation might well be that the materials patents did get beaten up over time. Part is the materials patents began to expire. Part is you can have as many legal documents as you want. It's hard to keep the world behaving, right? So in Asia and Korea, in particular, in India and so on, we began to see people step up and make this material, and so you got competitive pricing and other supply. Universal Display has been weathering that storm. In 2015, they signed a new deal with LG, and in the LG deal, we think they structured it the same way. One set of documents about all the uncontroversial patents, about manufacturing and the like, and a separate contract about materials. And then they told their investors, hey guys, we expect to make most of our LG money on uncontroversial patents. So yeah, we have a materials contract, but we don't think that's where we make our money. And then, as I record this in 2015, it's interesting to wonder what's going to happen in the future, right? If this technology takes off, it could well be that the uncontroversial patents are going to be really valuable, right? As you start to make TVs with a huge price tag, as compared to the price tag associated with the screen in a smartphone, right? In the TV, this technology is the reason you buy the TV. Whereas in the smartphone, the screen's one of many variables. So as TVs roll out, which we think they might, then it might be that the core patents become really, really valuable. You don't need the materials business. You do just great on the rest of your innovations. By contrast, if phosphorescent OLED goes the way of the horse and carriage, and there's some other screen technology that is also low energy, also flexible as these other virtues, then maybe those patents aren't so valuable, and it would have been nice to be in the materials business, which Universal Display doesn't seem like they will or are going to be meaningfully in over the years ahead. Again, I don't care much about the details of these particular companies. What I want you to see is contract language in action. Is this a great pair of documents? I don't think so. They really could have written this so much more cleanly if my read on it is correct, which is to say they could have written the clauses saying we have a disagreement about these patents, we agree about those, so we're pinning this set of payments to the ones we agree on, then we have this more contingent set of payments on the ones we don't agree on, and it might be those won't be triggered if we buy from someone else. Right? You can imagine them just saying it to make sure that they each understand. Now, it might be they chose not to do that because they knew people like me would be reading it, and it might well be that Universal Display, for instance, didn't want to telegraph to LG, to its investors, to other potential licensees, how much controversy there really was here in 2005. So maybe the obfuscation in this language is intentional. Samsung understood, Universal Display understood, but maybe their view was that if we don't understand, it's actually pretty nice. So I don't hold this up as a model of contract drafting, but I want us to be comfortable looking at even a messy contract like this. Let's look at a second example. The example I want to look at involves these two companies, PDL Biopharma and a company you might know, Genentech. As with some of the other examples, there's a lot of science and detail here that we don't need. What we need to know is that PDL holds a family of patents that are relevant to a bunch of Genentech's drugs. Indeed, prior to the deal we're going to look at, PDL and Genentech had another set of contracts in place, where PDL had licensed its patents to Genentech. Genentech had a bunch of drugs that it was paying royalties on, and all was good. What leads to the events that leads to this contract that we're going to look at is there were some disputes. There was some new drug that came out where it wasn't clear between the parties whether the new drug fell under the old deal. There was also a conversation as to whether the PDL patents were any good anymore. And so after some pushing and some shoving, the parties came together and made a new deal, a settlement, a contract, where they agreed how they were going to handle the patents and how they were going to handle the new drug. And that's what I want to look at with you. Here's the first text of this contract. And again, I apologize for the imperfections in the text. This one's really readable. The only challenge is it's taken from a public filing, so there's a little bit of a corruption here or there. I didn't want to edit the contract or change anything, so this is the publicly available version, as imperfect as it might be. Here's the deal. They signed it in 2003, and it's got this introductory language familiar to us from other contracts we've seen. It says, this settlement agreement is entered into on this 18th day of December 2003 between PDL on the one hand and Genentech on the other. We have the whereas clause, again, just setting up the deal so everyone can understand what's going on. It says, whereas PDL owns rights to the PDL patents. It's capitalized. That hints it's going to be a defined term. So whereas PDL owns rights to the PDL patents related to humanized antibodies and methods of making and manufacturing humanized antibodies, whatever those are, going on, and whereas Genentech develops, produces, uses, and or sells a number of humanized antibody products, including without limitation these drugs, Xolair, Raptiva, Herceptin, and Avastin. Another whereas clause, whereas PDL and Genentech are parties to that certain patent licensing master agreement from 1998, as amended at an earlier time in 2003, so on and so forth. So they acknowledge they have a prior deal that they were working under. Next whereas clause comes here. Whereas in 2003, Genentech received approval from the US FDA for the Xolair and Raptiva antibody products and continues to seek approval for Avastin. Whereas in 2003, PDL and Genentech disagreed concerning whether Xolair and other Genentech products infringe the PDL patents and concerning the validity and enforceability of that patent family. So now we're getting a sense of what's going on, right? We've got approval for the new drugs. When there's all this new money at stake, there's a fight now. Is Xolair infringing? Do I need a license to the patent? Are the patents any good? And again, they're setting this all up because now in this document, they are going to cut the deal to resolve these issues. This next bit is just interesting. I don't have to read it all to you, but this whereas clause continues to basically say both sides did a lot of work, a lot of thinking, and a lot of research prior to settling, right? We are well informed. So readers, courts, when you look at this later, we want you to know that this deal was made with our eyes wide open. So the whereas clause tells that both sides obtained extensive and thorough advice of counsel, had detailed factual information and legal analyses, engaged in extensive discussions with one another, on and on and on, right? Saying, look, we know what we're doing. Therefore, the parties agree as follows. Here are some definitions. Party means either PDL or Genentech. PDL patents means U.S. patent numbers, and those are the patents at issue. PDL patent family means those U.S. patent numbers and related United States patent applications owned by, assigned to, or subject to an obligation to assign to PDL. A bunch of other patent language there, but basically PDL family is these U.S. patents and U.S. patents related to them. Opposition, meanwhile, means Genentech's pending European Patent Office opposition to the European patent number, and there's the number. Remember, when they were signing this deal, one of the things going on is they had a disagreement as to whether the patents are any good. And the contract kind of memorializes an important piece of it. The opposition is a proceeding in Europe where Genentech had been pushing to get this patent thrown out. So not only were they talking together, hey, I've got Xolair, oh, I don't know if I want to pay under Xolair, on and on. They were talking, but there was also a real fight underway in Europe where Genentech had squeezed the trigger and had gone to the European Patent Office and said, there's a particular patent you guys should never have issued, blow it up. That's the opposition. And again, you'll see one of the things this contract does is tuck in that opposition. Okay, so here we go. Now we're going to resolve the dispute. So we have memorialized we had a contract, memorialized we're fighting over some new drugs, memorialized we're fighting over the validity and enforceability of some patents. Indeed, we're in Europe doing it in public. Now let's put it to bed. Here we go. The final resolution of patent disputes. Yeah, final. Not quite, it turns out. 2-1. Genentech has obtained detailed factual and legal information and has carefully analyzed and obtained... Remember this paragraph? Right, they say it again, right, almost unnecessarily redundantly, but I think they really want to make clear to a later court reading this that both parties were really well informed and are waiving whatever rights they waive knowingly. So another whole paragraph about both of us had lawyers, we both read everything, we both studied everything, we were wide awake, we had our cup of coffee, and we're still signing this deal. The last bit is interesting, just, making clear what's going on, that we've decided to resolve and settle the disputes forever regarding the validity and enforceability of the PDL patent family in order to avoid protracted litigation of those disputed issues and the business uncertainty and damage that litigation would cause. So almost like a whereas clause kind of communication, we've done our homework, and one of the reasons we're settling is we both want some certainty. Okay, 2-2. Subject to a later provision, Genentech agrees and stipulates that each of the 4 products is, with respect to the PDL patents only, a GNE licensed product and a licensed product. What's that mean? Well, Genentech agrees that the products at issue, these drugs that they were fighting about, look, they fall under the contract. Right, that with respect to the PDL patents, these are licensed products, which means they're royalty bearing. So when I sell them, I'm going to owe a royalty to PDL. Right, so Genentech gives here. They say, look, we'll stipulate that these drugs do come under your patent rights. 2.3. Genentech further agrees and stipulates that each of the claims of any present or future issued patents within the PDL family is valid and enforceable. Right? Even ones we haven't seen yet. We agree they're valid and enforceable. We're not going to fight them. They're valid. They're enforceable. They fall under these deals. We'll pay them. Right? We're not going to fight with you about this patent family. Okay, keep going that theme then. 2.4. Genentech agrees, covenants, represents, and warrants. Again, note the belt and suspenders language here. Right? Might have been just fine to say we agree, but all this extra language with legal meaning, trying to say, look, we really mean to be tied here. Genentech agrees, covenants, represents, and warrants that it will not, 1, knowingly or intentionally file or otherwise initiate or participate in a lawsuit, arbitration proceeding, U.S. Patent Office interference, or any other legal proceeding in the United States in which Genentech alleges or seeks a determination that one or more claims of an issued patent within the family is invalid or unenforceable. Just stop there. This first bit, right, what are we saying? We're saying we won't knowingly or intentionally go after you in the U.S. to knock out your patents. Go to the next piece. We also won't knowingly or intentionally provide assistance to anybody else who might be seeking a determination that one or more claims of an issued patent within the family is invalid, except as required by law, right? If they get a subpoena, they can't fight. What can they do? 3, we won't knowingly or intentionally encourage another party to allege or seek a determination, right? So not only will we not help, we won't even give them a high five. 4, knowingly or intentionally refuse to pay royalties under the licensing agreement on the ground that one of the claims is invalid or unenforceable. So we'll keep paying. Not only will we not fight, we'll keep paying. And we also won't knowingly or intentionally terminate a PDL license agreement on the ground that one or more claims is invalid. Okay, so this is the clause you'd expect. We agreed our drugs are under your patents, and now we promise to lay down our weapons and not fight these patents. We're making a deal. We're settling. Let's all go home. Not to beat a dead horse or anything, but we go on and say it kinda again. Section 3.1. As part of this settlement agreement, as consideration for the promises, covenants, warrants, and agreements therein, the parties also agree, and check it out, what do they agree? They agree that Genentech agrees in covenants that within 7 days after the effective date, Genentech will file with the European Patent Office a withdrawal of the opposition in the form attached here to as Exhibit B. Right? What is this? Well, we just agreed we're not going to fight you, but remember, there already is a fight underway. There's a fight underway in Europe called the opposition, where Genentech already was beating up the patent, probably doing a pretty good job with it, right? That's why we end up getting this settlement agreement. Genentech's doing damage to the patent. So in addition, in the prior piece of contract to saying, look, we're not going to fight you anymore, they then also specifically say, we will stop the fight already underway. Within 7 days after the effective date, we will ask the European Patent Office to back off. So what could possibly go wrong? Well, it turns out in Europe, there is a special kind of patent-like right which can functionally extend the life of certain kinds of patents. So you could have a patent in Europe and it's about to expire, and you can file to get a couple more years under these special provisions in Europe. Now, this isn't something that we talk about in our class, but it's something really well known. Indeed, my friend Wikipedia has a page on it. It's called Supplementary Protection Certificates, SPCs, and Wikipedia tells you basically what you need to know. In Europe, there's a Supplementary Protection Certificate, an SPC. It's a sui generis, that means it's kind of on top of regular patent rights, that extends the duration of certain rights associated with a patent. So guess what happens? We have this deal that we just read, which seems to tuck everything in. Genentech's going to pay for the drugs, Genentech's not going to fight anymore. I assume that in consideration for laying down its weapons, it gets a sweetheart deal. We look like we're tucked in. Then, it turns out, in Europe, PDL starts to lean on these SPCs, starts to lean on these extra years under the special law, and Genentech either directly challenges them or Genentech helps someone else challenge them. The details there are messy and I don't want to get into them, but Genentech takes a shot at these add-on years. And the question is, does that violate the contract? Didn't Genentech say that it wouldn't fight, that it wouldn't help others fight, it wouldn't encourage others to fight? If you fight the SPCs, did you just violate the contract? Because man, if you did, then a whole bunch of penalties are going to kick in maybe in the contract. There's a section of the contract I haven't shown you, which lists out all the consequences of breach, and they are potentially gnarly. So the question is, if you fight the SPC, did you just violate the contract? Here's the money language again, right? This is the paragraph where Genentech agreed not to fight. But read it closely. Genentech agreed not to knowingly or intentionally file and fight about the PDL patent family. It agreed not to help others fight about the PDL patent family. It agreed not to give high fives to people who fight about the PDL patent family, and on about the PDL patent family. So who is this PDL patent family? It's a capitalized term. We read the definition, but now it really matters. So here it is again. Definitions. PDL patent family means U.S. patent numbers, boom, 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 and related United States patent applications. United States patent applications. Uh-oh. Genentech agreed not to fight the PDL family. And Genentech will argue, it didn't. I didn't fight the U.S. patents. I didn't fight that one, or that one, or that one, or that one, and I didn't fight anything related in the U.S. patent applications bucket. I fought something in Europe. And by the way, the definition below points out that both parties understood that Europe was a different place, because when they wrote the contract, they talked about the European Patent Office. They knew about oppositions and all the rest. Yet when they defined PDL patent family, gosh, there's a pretty good argument that what they defined it to mean is U.S. patents and U.S. applications, which means Genentech's promise not to fight is a promise not to fight in the U.S. and not a promise at all about fighting where a lot of money turned out to be at stake, Europe. All right, I hope you enjoyed that introduction to reading contracts. Again, lots of other examples we could look at, lots of details you'll have to talk with counsel about when you're doing deals, when you're reading contracts, and so on. But my hope for you is that if you see a bunch of these, some with me, some in your actual day jobs and the like, over time you get comfortable seeing all this language, comfortable reading it through, and asking questions. Asking, say, hey, time out, did we really cover what we needed to cover? Because often the non-lawyer is going to know stuff the lawyer doesn't. They're going to see holes, going to see contingencies that will help not only the lawyer write a good contract, but also help the parties make sure they really understand the deal. Again, to me, that's a huge part of the contract writing process, informing both sides about what we're really trying to do, so we have a true meeting of the minds and can move forward hopefully without litigation, but instead in the very partnership we both willingly entered into.